Hi, this is Subramaniam Shankaran. So we're going to learn about the difference between the common law and the civil law. Common law as a legal system and civil law as a legal system. It's a common mistake that we actually do when we discuss about the civil law. Okay, there is a difference. Okay, civil law as a legal system is one, and civil law as such is another one. Okay, we have civil law, criminal law. All these things come under the common laws. Okay, so civil law is a legal system and common law is a legal system. Okay, they have got a huge difference. Okay, between themselves. Okay, we are going to have a look into that. Just to give you an indication, common law is a legal system. Okay, is for the countries that have been ruled by the British. Okay, the United Kingdom. So the Commonwealth nation they actually followed. Okay, where all their influences were there. Okay, they were actually going. They have actually gone for an common law. But if you look at the civil law as a legal system, okay, it's for other European countries like Spain, France, etc. Okay, so the civil law was introduced by the Byzantine emperor, okay, Justinian, okay, in the sixth century AD, and Henry too, okay, in the 12th century, he wants to have a common law across the country, okay, the United Kingdom message, okay. So he called that as a common law. So, okay, this is the roots for the common law and the civil law as a legal system. Now, sources, okay, the common law primarily is on the judicial precedents. Okay, what do you mean by a precedent? Okay, the precedents is, the statements or the judgment that has been given previously. Okay, so we say predecessor, okay, the successor and predecessor, right? So when you say precede, okay, so precede is something that we are following, okay, that is preceding it, okay, which is before, okay, something, okay. So the precedents are the judgments that have been made previously by the other judges. So the common law predominantly uses that. Okay, now there are books that are actually written for the common law as well, but initially the common laws were not codified. Civil law was actually codified. So civil law is based on the comprehensive legal codes or statutes that are primarily source of law. Okay, there is a codes that the judge will actually refer, okay, before they start giving the judgment. Now, coming on to the roles of judges. In common law, judges play more active role in creating a law through their rulings and interpretation. So in India also, we say according to the Supreme Court judgment, okay, according to the High Court judgment, okay, the judges can interpret those precedents, okay, but in civil law, it is actually not possible. So judges mainly apply existing codified laws, okay, so they don't consider, the judgment made by the previous judge in a similar case, no. So they mainly apply the existing codified laws, okay, to case basis. Use of precedents, as we discussed, okay, so common law use this precedents, okay, in a very large manner, but in civil law, okay, it's being used less because mostly, focusing on the codified laws, okay, not on the precedents. Legal codes, okay, so the common law legal system does not rely on the comprehensive legal codes, but the civil law actually does. In common law, okay, the appointment of judges is made on the, the amount of experience that they have got as a practicing lawyers. Okay, so I personally, a lot of people who have been appointed as a judge, and they have been very successful advocates. Okay, they had been practicing for close to 20, 25 years, and then they had given an post appointment as a judge. Okay, but in case of a civil law, okay, so it's like a graduation. So they complete the law school, and based on the merit, they had been given the role as a judge. Okay, but in case of common law, in fact, I'm from India, so the common law is followed in India, and we majorly look at the rulings or precedents given by the other judges also. So the once the judge is actually appointed, he's going to occupy the position. So we can most of the people in the court they know them because they had been practicing lawyer in the same court or in a court in a different city. Okay, and they had been highly successful. So when they actually sit and give the judgment, okay, they give the judgment not really based on the knowledge that they actually have and what they have actually read, but it's also from the competency. There are things that you can read. There are things that you can get from what you have read, but your experience gives you the maturity. Okay, so in the common law, and not to undermine the civil laws, the legal system, but this is my personal view. Okay, because I had been with these advocates and the judges. Okay, so the immense experience they occupy the position as a judge. Okay, now adaptability. See, common law, the adaptability is pretty easy because it's all based on case-to-case basis, what's actually happening in the society. Okay, so adaptability is easy, but in civil law, the adaptability is not that easy, but it is still possible. For example, we have got ML, DL, and then we have got AI. Okay, so we are on 2024. So today, the artificial intelligence is actually taking a major shape in the world. Okay, now if it's going to be a common law, okay, ever since there's a new case with respect to artificial intelligence, adapting it becomes very easy. Okay, I'll call an SME, and the advocates will call an SME. They will to the court, and we will get a fair idea of what this artificial intelligence is. But civil law is based on the codified laws. Okay, we need to amend the codes. Okay, for the applicability of the civil law with respect to the artificial intelligence. That could have already been there, but I'm not saying no. Let's leave the artificial intelligence. Tomorrow, a new technology comes in. So the civil law needs to be amended for the codified for the codes, but common law will have the adaptability right away. Okay, that's the advantage of the common law as a legal system. So geographic distributions, as I actually told you initially, where all the UK had an influence. Okay, the colonial UK colonies or British colonies. Okay, they all follow the common law more or less. Okay, but other countries, Latin America, most of the other part of the Europe and parts of Africa and Asia, okay, which were not influenced by the British in a large way, they will use what is called as a civil law. There are a lot of other laws, okay, religious law, customary law, that we will actually see on the further videos to follow. But the civil law is a legal system. Okay, so it's been followed by other parts, predominantly by other parts of the world that was not a British colony. Okay, so learn CISSP the Subbu way. Okay, so my name is Subramaniam Shankaran. You pass it on your first attempt. CISSP is not a one-time training that requires a hand-holding. I will hand-hold you until you are actually certified. And there are so many students that they have been certified by IEEE, they have been trained by me. Okay, they will also give you a guest lecture. Okay, so all of us will join together to ensure that you pass your CISSP the first attempt. Thank you very much and stay connected. Cheers then. Bye-bye.